Hello everyone. Today we will solve a few most important MCQs on our Indian Evidence Act 1872. Okay, so those who are preparing for All India Bar examination this year, this video lecture will be very helpful to you all. Okay, so without any further delay, let's start today's session. Okay, see the first question is our law of evidence is options are lex telinins, lex fori, and lex loci solutionis, and lex citus. Okay, so the correct answer would be our lex fori. Okay, so the correct answer would be our lex fori, that is law of the land. Okay, so in this case, option B would be the correct answer. Okay, so now moving to next question. Next question देखिए, examination is very important question. Okay, very important question. Cross examination of a witness क्या होगा देखिए. Options are must be relevant fact and has to be confined to what the witness testified. Must relate to relevant fact. Okay, जो हम लोग का क्रॉस एग्जामिनेशन होगा वो क्या होगा, must relate to relevant fact. Okay, and but need not be confined to what the witness testified in examination in chief. Okay, एग्जामिनेशन इन चीफ में जो किया गया था उसी में कन्फाइंड नहीं रहेगा. दैट मीन्स बट it must be related to relevant fact. Okay, that means cross examination of a witness must relate to relevant fact. जो हम लोग का अंडर सेक्शन 137 के अंदर जो क्रॉस एग्जामिनेशन होता है उसमें जो फैक्ट वो रिलेवेंट होना पड़ेगा, बट नीड नॉट बी कन्फाइंड टू व्हाट द विटनेस टेस्टिफाइड. जो यही वही तक सीमित नहीं रहेगा जो विटनेस ने टेस्टिफाई किया है ड्यूरिंग द एग्जामिनेशन इन चीफ. ओके, सो इन दिस केस करेक्ट ऑप्शन वुड बी ऑप्शन बी. Okay, option B would be the correct answer. Okay, now moving to next question. नेक्स्ट क्वेश्चन इज री एग्जामिनेशन. ओके, री एग्जामिनेशन ऑफ ए विटनेस क्या है देखिए. ऑप्शंस आर कैन बी फॉर द पर्पस ऑफ व्हाट इज लेफ्ट ओवर इन द एग्जामिनेशन, कैन बी फॉर द पर्पस ऑफ एक्सप्लेनिंग द मैटर्स रेफर्ड टू इन द क्रॉस एग्जामिनेशन, can be for the purpose of explaining matters referred to the examination in chief, and above all of the above. So the correct option would be option B. Okay, that means here option B would be the correct answer. क्या बोला है, री एग्जामिनेशन जो होता है, री एग्जामिनेशन किसका होता है, ऑफ द विटनेस जो जिसका होता है. सो इट कैन बी फॉर द पर्पस ऑफ एक्सप्लेनिंग द मैटर्स रेफर्ड इन द क्रॉस एग्जामिनेशन. जो क्रॉस एग्जामिनेशन में ऑलरेडी हो गया है उसको एक्सप्लेन करने के लिए विटनेस को फिर से री एग्जामिनेशन होता है. सो इन दिस केस ऑप्शन बी would be the correct answer. Okay, now moving to next question. Next question is our after re-examination. Okay, re-examination होने के बाद of a witness, the adverse party has what? Options are right to further cross-examine the witness, afresh in general, has no right to cross-examine the witness, right to further cross-examine the witness only when a new matter is introduced in the re-examination. So the correct option would be option C. So the correct option will be option C. That means after re-examination क्या होगा, the adverse party जो दूसरा party होगा, adverse party has the right to further cross examine the witness only when a new matter, अगर कोई भी new matter introduce होता है in the re-examination में. Okay, so in this case क्या होगा, option C would be the correct answer. Okay, now moving to next question. नेक्स्ट क्वेश्चन देखिए क्या. नेक्स्ट क्वेश्चन इज ड्यूरिंग री एग्जामिनेशन. पहले क्या होता है, चीफ होता है, पहले चीफ होता है, ठीक है. उसके बाद होता है क्या है, नंबर 1 है चीफ, उसके बाद क्रॉस एग्जामिनेशन, एंड नंबर 3 लास्ट क्या है, री एग्जामिनेशन. ओके, चीफ एग्जामिनेशन, क्रॉस एग्जामिनेशन एंड री एग्जामिनेशन. सो एक के बाद एक होता रहता है. सो अभी क्वेश्चन क्या दिखा है, ड्यूरिंग द री एग्जामिनेशन ऑफ ए विटनेस क्या है. ऑप्शन सर ए न्यू मैटर कैन बी इंट्रोड्यूस एज ए मैटर ऑफ राइट जनरली, ए न्यू मैटर कैन बी इंट्रोड्यूस्ड only with the permission of the court. Okay, So the correct option would be option B, that is a new matter can be introduced only with the permission of the court. So in this case option B would be the correct answer. Okay, now we to next question. Next question. Okay, next question देखिए. Leading question can be asked. Okay, during options are examination in chief, cross examination, re-examination, and all of the above. Okay, so the correct answer would be our option B. Okay, option B, that is cross examination. क्वेश्चन क्या है? लीडिंग क्वेश्चन कब पूछा जाएगा? सो आंसर वुड बी लीडिंग क्वेश्चन कैन ओनली बी आस्क्ड ड्यूरिंग क्रॉस एग्जामिनेशन. ठीक है, अगर क्रॉस एग्जामिनेशन नहीं होगा देन लीडिंग क्वेश्चन कैन नॉट बी आस्क्ड. ओके, सो इन दिस केस क्या होगा देखिए, इन दिस केस ऑप्शन बी. ओके, इन दिस केस ऑप्शन बी वुड बी द करेक्ट आंसर. ओके, नाउ मूविंग टू नेक्स्ट क्वेश्चन. Next question is our court can permit, okay, leading questions, okay, during the examination in chief or re-examination. Options are if they are referred to the matters which are introductory, if they are referred to the matter which are undisputed, and if they refer to the matter which are sufficiently proved. Okay, sufficiently proved. Okay, लास्ट ऑप्शन है इफ दे रिलेट टू आइदर ए बी और सी. सो द करेक्ट ऑप्शन वुड बी आवर ऑप्शन डी. दैट मीन्स ऑप्शन डी वुड बी द करेक्ट आंसर. दैट मीन्स कोर्ट कैन आस्क. ओके, कोर्ट परमिट तभी कर सकते हैं लीडिंग कोई भी एक लीडिंग क्वेश्चन को ड्यूरिंग एग्जामिनेशन इन चीफ एंड री एग्जामिनेशन. कब होगा? अगर वो रेफर करता है विच आर इंट्रोडक्टरी, अगर कुछ भी एक लीडिंग क्वेश्चन है जो रेफ़र करता है वो रेफ़र करता है मैटर विच इज़ इंट्रोडक्टरी. कोई भी अगर इंट्रोडक्टरी पोर्शन है तो वो कोर्ट परमिट करेगा. ठीक है, तो कोर्ट परमिट देगा. ठीक है, और इफ़ दे रेफर टू द मैटर्स विच आर अनडिस्प्यूटेड, अगर अनडिस्प्यूटेड कोई भी एक मैटर है देन उसको कोर्ट परमिट दे सकता है. ठीक है, अगर अनडिस्प्यूटेड हो. ठीक है, अगर इंट्रोडक्टरी हो तब भी दे सकता है, अनडिस्प्यूटेड हो तब भी दे सकता है. एंड इफ़ दे रेफर टू द मैटर विच आर सफिशिएंटली प्रूव्ड, अगर सफिशिएंटली प्रूव्ड हो गया कोई भी फैक्ट देन in that case also the court can permit the leading question, okay, to be asked in to permit दे सकता है कब to be asked in chief and re-examination. Okay, so now moving to next question. Next question is a leading question has been defined. Okay, a leading question has been defined as a question suggesting to the answer. Okay, which the person putting it wishes or expect to receive under which of the following sections. Okay, so options are section 141 of the Indian Evidence Act, section 141 of the Indian Evidence Act, section 142 of the Indian Evidence Act, section 143 of the Indian Evidence Act. So the correct answer would be option B, that is section 141. That means section 141 में हम लोगों का लीडिंग क्वेश्चन के बारे में डिफाइन किया गया है. ठीक है, लीडिंग क्वेश्चन has been defined under which section of Indian Evidence Act? Under section 141 of the Indian Evidence Act. Okay, so in this case the correct option would be option B. Okay, so now moving to next question. Next question देखिए, ड्यूरिंग एग्जामिनेशन इन चीफ और री एग्जामिनेशन. ठीक है, क्या देखा है, क्या ऑप्शन दिया है? लीडिंग क्वेश्चन कैन नॉट बी आस्क्ड अंडर एनी सर्कमस्टेंसेस. ओके, ये फॉल्स है. Okay, leading question on certain matters can be asked without the permission of the court as a matter of right. ये भी false है. Leading question on certain matter can be asked only with the permission of the court. Okay, so this is the correct. Okay, so in this case the correct option will be option C. This question is under section 145 of the Indian Evidence Act, a witness may be cross-examined as to the previous statement to which of the following. Okay, so the options are without providing the same and without showing the same to the witness. So the correct option will be option A, that is without proving the same, and the without showing the same to the witness. Okay, so in this next question, objections as to the admissibility of a document in evidence, which are the following. So options are: can be made at any stage during the trial, can be made at the first opportunity when the document is tendered in evidence, and can be raised for the first time in appeal. So the correct option would be option B. दैट मीन ऑब्जेक्शन कोई भी एक डॉक्यूमेंट का अगर एडमिसिबिलिटी को लेकर कोई ऑब्जेक्शन आता है तब कब दिया जा सकता है, कैन बी मेड एट द फर्स्ट इंस्टेंस व्हेन द डॉक्यूमेंट इज टेंडर्ड एज ए एविडेंस. Okay, so the correct option would be option B. That is, option B would be the correct answer. Now moving to next question. Question is: a party or person who calls the witness can be permitted to cross-examine the witnesses so called by him as provided under which of the following sections of the Indian Evidence Act? So the options are: under section 152 of the Indian Evidence Act, under section 153 of the Indian Evidence Act, under section 154 of the Indian Evidence Act, under section 155 of the Indian Evidence Act. So the correct answer would be option C. That is, under section 154 of the Indian Evidence Act, a person who calls the witness can be permitted to cross-examine the witness. Okay, so in this case, option C would be the correct answer. Okay, now moving to next question. Is our court questions can be put by virtue of which of the following? Okay, under the options are section 164 of the Evidence Act, section 165 of the Evidence Act, section 166 of the Evidence Act, section 167 of the Evidence Act. So the correct option would be option B, that is 165 of the Evidence Act. So in this case, option B would be the correct answer. Moving to next question. Court questions under section 165 of the Evidence Act can be put to which of the following? Options are: if any witness, any party, both A and B, neither A nor B. That means court question under section 165 में जो question पूछा जाता है by the court can be put to whom? Can be put to both witness and the party. So in this case, both are the correct answer. That means option C is the correct option. So in this case, option C is the right answer. Okay, now move to next question. In which section of the Indian Evidence Act presumption as to dowry death is provided? Options are: section 111A, section 111B, section 113A, section 113B. So the correct option would be option D, that is section 113B. Okay, has laid down the provision regarding what? Presumption as to dowry death. Dowry death. Okay, now on to next question. Section 114 of the Indian Evidence Act is related to which of the following? Options are: presumption as to abatement of suicide by married woman, presumption as to the absence of consent in certain prosecution for rape, presumption as to abatement of suicide by woman, none of the above. So the correct option would be our option B. That means section 144 has laid down the provision regarding presumption as to the absence of consent. Okay, in certain prosecution of rape. So in this case, option B would be the correct answer. Now on to next question. Next question is: under which of the following sections of the Indian Evidence Act opinion as to the handwriting has been considered to be relevant? Options are: section 100, section 47, section 48, section 53A, section 56. So the correct option would be our section A, that is section 47 of the Indian Evidence Act. So in this case, correct option would be option A. Now to the next question and the last question. Okay. Uh, which of the following is not correctly matched? Okay. Options are: hostile witness, section 154. This is correct. Burden of proof as to ownership, section 110. This is also correct. Refreshing memory, section 139. This is also correct. Professional communication, section 124. This is incorrect. Okay. That is, professional communication has been defined under section which? Under section 126 of the Indian Evidence Act. So, so the correct option would be option D. Okay, option D. So in this case, the correct option would be option D. So this is for all today. If you liked this lecture, please like this video and subscribe this channel. Okay, I have already started MCQs on constitution, CRPC, BNS, BNSS, and so on. So if you don't want to miss any of these lecture, please subscribe this channel. Okay, thank you. Thank